an appeal in the matter of Adidas AG and others and Thom Browne Incorporated and another.
Yes, Miss May.
My lords, my lady, good morning. I appear on this appeal with my learned junior, Mr. Key, for the appellant. My learned friends, Mr. Roberts, KC, and Mr. Cronin are here for the respondent. As the court will understand, the appeal concerns the validity of 6 trademarks, which are all position marks. It's the first case before the English courts to consider the validity of this type of trademark. May I start, please, with some terminology? A position mark is a mark which combines the placing of a particular sign on a particular part of a product. It is the combination of the sign and its position on the product that comprises the subject matter of the mark and enables the mark to serve as an indication of origin and to be distinguished from other marks, from those of other undertakings.
Pausing there, I would agree with that definition, but as you're probably aware, that's not the definition you find in the implementing regulation. And one of the things I've been trying to discover is I have a belief that the definition in the implementing regulation comes from WIPO, but I've been completely unable to find the WIPO source for that. And I don't think it matters, but if anybody can find the WIPO source, I would be obliged.
We will endeavour to try and find it, my lord. We may not find it over lunch, but we can send it through the usual channels.
Yeah, thank you.
Thank you. Typically, the position mark includes a combination of a pictorial representation and a written description. Sometimes the term graphical representation is used in the case law in a way that is synonymous with the picture, but sometimes the term graphical representation is used to encompass both the picture and the words. Strictly, the proper term is that, or the proper use of the term graphical representation is when it refers to the visual representation and the written description together. And my lords will see that when we come on to it in the Glaxo decision. My lords and my lady, just for your note, that will be at paragraph 34 and 63 of Glaxo, and I'll come on to it. But to avoid confusion, what I'm going to do is use the term pictorial representation when I'm talking about the picture, and the words written description when I'm talking about the words. And when I use the term graphical representation, I mean the mark as a whole, the combination of the picture and the words. As the court will have seen, the case concerns 6 marks which comprise 3 stripes. That's a shorthand for 3 straight parallel stripes which are of equal width and spacing set against a contrasting background. All 6 marks comprise a pictorial representation and a written description. The pictorial representation shows what the 3 stripes looks like and where they are positioned on the garment, and the written description does the same thing in words. And we summarise the 6 marks.
Pausing there, again, I don't think this terribly matters, but it's always helpful, I think, to have the framework in mind. It is, of course, optional to have a written description at all.
It is, which is why I use the word typically. But my lord is absolutely right. It is optional to have a written description.
So it was your client's choice, first of all, to have a written description at all.
Indeed.
They could have just relied upon the picture.
Indeed.
And having decided to include a written description, the choice of wording was your client's.
Indeed. So we summarise the 6 marks at paragraph 3 of our skeleton, which is core bundle page 30, and we've set out the pictorial representation and the written description side by side. And what the court sees when you look at the written description It describes what the stripes look like in the form of 3 parallel, equally spaced stripes. And we say that description is consistent with the pictorial representation, albeit that you obtain additional information about the stripes from the picture, namely that they are of equal width, the same colour, and set against a contrasting background. The written description also describes where the stripes are positioned on the garment, running along 1/3 or more of the length of the sleeve, the side of the trouser or short, or the side of the garment, as the case may be. And that description is also consistent with the pictorial representation, albeit that the variation in the length is not illustrated in the pictorial representation. In the judgment and the skeleton arguments of the parties, the marks are identified by reference to the type of product in the pictorial representation. So they're referred to as the tracksuit top mark, the tracksuit bottom mark, and the vest mark. And there are 2 of each type. For each pair,
sorry to interrupt again. Sorry, a question I meant to ask earlier, but is pertinent at this stage. One thing that puzzles me is that, according to all the paperwork that we have,
yes,
there are 4 appellants, but by my reckoning, correctly speaking, there's only one, viz. The proprietor of the registrations, Adidas AG.
Yes, I mean, that's not a point to which I've turned my mind at all, I have to confess. But logically, my lord must be right, strictly speaking. There's only one registered proprietor, and it is the first defendant.
Yeah. Okay.
But I don't think it's a point of procedure that matters either way.
No, I just want to be
precise.
Precise.
Yes, and my lord is absolutely right. Yeah. So what my lord and my lady will see is that there are 3 pairs of marks, and for each pair there are only 2 differences. The first is that for one mark in each pair, the written description contains the additional words as illustrated below. You see those words in the middle of the written description. The judge held in her judgment that those words didn't make any difference to her analysis. That's at paragraph 202 of her decision. The second difference between each mark in the pair is that one mark of each pair is registered as a 3-dimensional mark, whereas the other, the registration, doesn't classify the mark in terms of its type at all. Again, this was addressed by the judge in her judgment at paragraph 142, subparagraph E, and it was common ground before her that nothing turned on the characterization or the difference between them. Just as a point of history, the registration, which does not say what type of mark the mark is the mark which is the CTM that's been converted into the national mark. So in each case, the national mark, which was historically a CTM, starts with the number 009, and you will see as you go through our table that every other mark starts with 009, and that's a converted mark. And it's the converted mark which doesn't have a type, and the UK, the national mark, is registered as a 3-dimensional mark. But like I say, it was common ground that nothing turned on that.
I'm grateful to you for pointing that out, because I hadn't turned my mind to that question. I don't think it matters, as you've said, but what that tells us is that when we are considering the validity of these 6 marks, we are applying 2 different legislative regimes, because in the case of the converted marks, we apply the regulation because it's the regulation that applied when they were registered.
Yes, but I don't think that makes any difference.
No, but one needs to be clear as to what the operative legal regime is.
Absolutely right. Absolutely right. And both pairs of marks were registered back in 2003.
Yeah.
For the converted marks, their effective date is the 3rd of November 2003, and for the national marks, their effective date of registration is the 5th of February 2003. And that's why we refer to the old version of Section 1 of the Trademarks Act, because that's the relevant section that applies.
Sure.
The question of registration, because my lord is absolutely right. The question of registrability is assessed as at the date of the application of the trademark, not as of today's date.
And again, to just flesh that out a little more, when we're talking about the UK marks, as you say, it's the original version of Section 1 of the 1994 Act.
Indeed.
Implementing the first Council directive.
Indeed. Yes, indeed. And the last sort of point of history is at that time, the classification of a position mark was not available as an option. And that's one of the reasons why the characterization of the mark as either a three-dimensional mark or not having a type ascribed to it at all was perceived to not matter for the purposes of this case in the court below, because it was common ground between the parties that these marks are in fact position marks. It's just that at the time on the form when you made the application, the option of a position mark wasn't available as a tick box. And from in the UK procedure at the time, you had to designate a type. And so the practice was to designate a three-dimensional mark, I think. But
sorry, I'm a little puzzled by that. I'm not questioning the correctness of it, but
yes.
So let me get this straight. So first of all, the marks that were originally CTMs, this question doesn't apply, is that correct?
I'm sorry, please ask the
The
question.
marks that were originally CTMs,
Yes.
the question of designating the type of mark doesn't apply. Is that what you're saying?
What I'm saying is, in relation to, at the time the marks were applied for, the option of designating them as a position mark, that being the type of mark, wasn't available.
Sorry, that's not the question. The question is about the statement, three-dimensional trademark,
Yes.
and the origins of that statement. I appreciate it doesn't really matter at the end of the day, but I want to be clear. So, remind me, is that for the CTMs or for the UK marks?
That's for the UK marks.
Right. So, and you're saying that on Form TM3, as it existed at a relevant time, you were forced to tick a box as to the type of mark. Is that correct?
Well, certainly that's my recollection. We looked into this.
I want to be. I'm not sure that's correct. I mean, I'm not saying it's wrong either. I'm not really just not sure.
Perhaps we can park it and I'll check over lunch. Because we certainly had this conversation before the learned judge at first instance. And I confess I haven't gone back and checked, but that was my recollection from what happened before the judge. But like my lord understands, the point doesn't matter. I was just trying to give my lord the full picture of the history of the marks, as it were.
Well, I'm grateful. I'm grateful.
But what my lords and my lady will understand is that the issue in this case, or the registrability attack in this case, turned on whether the marks, sorry, let me start again. It's clear from the marks, all 6 of them, that they comprise variations that are not illustrated in the pictorial representation. And the attack on the marks before the court below was whether those variations were permissible or not. And that's the heart of the appeal. Really, the fundamental question before this court is whether a position mark that envisages variations that are not illustrated in the pictorial representation will necessarily be a mark that lacks clarity and precision. And we say fundamentally the answer to that question must be no, both as a point of principle and by reference to the marks in this case. And with the utmost respect to the learned judge, we say that she failed to interpret the marks properly, and in so doing reached a conclusion on registrability that isn't supported by authority, failed to take into account relevant factors, and was internally inconsistent.
Now, you've expressed the judge's decision there in terms which I would like to consider, because the ultimate question is whether the registrations comply with the definition of a trademark in the directive and the regulation, there being no material difference between the two. And as we know, the definition contains three ingredients.
Yes.
One, it must be a sign. Two, it must be capable of graphical representation, which carries with it requirements of clarity and precision and so forth. And thirdly, there must be the capacity to distinguish. Now, as I read the judge's judgment, although she's not explicit, what she concludes in relation to each of the 6 judges' marks in issue is that there is non-compliance with both the first condition and the second condition. That is to say that what is sought to be registered is neither a single sign, nor is it clearly and precisely represented. Now, the way you expressed her decision was purely in terms of the second condition.
Yes.
And therefore, I think at an early stage, I will need you to clarify whether you would accept my characterization of the judge's reasoning, or whether you would say, actually, no, it's not based on the first condition at all, it's based on the second condition.
Yes, I'm planning on addressing the court on that very issue.
Okay.
My lord. Perhaps I can tell you what the structure of my submissions is intended to be, so you know the order in which I want to take the points, if it's convenient for the court. The first, what I'd like to do is just spend a little bit of time on the law. I don't want to spend too long on it because obviously my time before you is limited, and we tried to do a thorough exercise in our skeleton, but it's important to just flesh out a couple of points. I'm obviously acutely aware that my Lord Justice Arnold in particular is very familiar with all the authorities. What I then wanted...
Lord and my lady are not so familiar.
No,
this
indeed.
is a court of 3.
Indeed, which is one of the reasons why I want to spend a little bit of time on it. And obviously, I'm in that regard, I'm here to assist. Secondly, I then want to spend time walking through the judge's decision, so I can explain to the court the relevant parts of the judgment and why we say the learned judge went wrong. And in that regard, we've identified one overarching error in the judgment with 4 parts to it in our grounds of appeal, which are in the core bundle of tab 2. And for reasons which I hope will become apparent, what I'm proposing to do when I come on to the grounds is take ground 1B first, then address grounds 1A and 1C together before finally addressing the court on ground 1D.
Why are they called 1A, B, C, D? I mean, I understand you say it's all part of the same thing, but it's much easier for us to just call them 1, 2, 3, and 4.
Very happy to do that, my lord.
Thank you. So you're going to start with 2, then you're going to do 1 and 3, and then 4.
Yes.
Helpful. Thank you.
If I may start with the law, we addressed this in our skeleton from paragraph 11, which is bundle page 34. The relevant statutory provision is section 1.1 of the Trademarks Act in its original form, which we set out in paragraph 12. And as my Lord Justice Arnold has already pointed out, that provision comprises 3 requirements for registrability. The first is that the mark must be a sign. The second is that it must be capable of being represented graphically. And the third is that it must be capable of distinguishing goods or services of one undertaking from those of other undertakings. We summarise the relevant case law in our skeleton from paragraph 15. And I wasn't proposing to go through them all. And in fact, I think it is perhaps most time efficient and convenient to go straight to the Glaxo decision, because that is the most recent Court of Appeal decision on the question of registrability. And in that decision...
But on the other hand,
yes,
it is exclusively a decision on the second condition, as I read it. It's not a decision on the first condition.
That is correct. But the reason I was going to use it as the basis of my submissions is because it goes through all of the other authorities.
Well, yes and no. Because it's about the second condition, it's not necessarily so helpful about the first. And of course, as you know, the first condition was front and centre in the two cases that preceded it, that were heard at the same time by the same constitution and judgments given in the same day,
Yes.
viz. Spear and Zinger and Nestle and Cadbury.
Yes.
And so those two decisions, seems to me at the moment, subject to anything you might wish to say, are a bit more helpful when considering the first condition.
Yes, indeed. Well, perhaps I can start with Glaxo.
Sure.
And we can pick up the other, because it, like I say, it goes through all of the other decisions, and then we can pick them up as we go. So this is in the first half of the authorities bundle, A1, and it's tab 3. So the ambit of the appeal is set out in paragraph 1 on page 36, and it's clear from that paragraph 1 that the question before the court is whether the registration was clear or precise, and whether it would be perceived unambiguously and uniformly or not.
Yes, well, for those who are not familiar with this, it's helpful to point out that we have a monochrome reproduction here, but in the original, it's colour.
It is colour.
It's 2 shades of purple.
Yes, and I think that was one of the reasons why we added at least one colour version of something.
The one you added was the colour version of Iceland and Babek.
Yes,
And this might be a convenient juncture to mention, in case you're not aware of it, that a different constitution of this court will be hearing in that case next week.
we are aware. Thank you.
Very good.
But there's a colour version of the purple contrast in the Babek decision, and the colour one we've inserted at the back of the second authorities bundle. So it's tab 22, and it's bundle page 415, and that's where you can see what it looks like. The problem is all of the all of the reported journals don't reproduce in colour, and so this is a non-compliant copy because it doesn't come from a law report, but at least it's got it in colour.
Indeed.
So the trademark, back in Glaxo itself on bundle page 37, paragraph 2, paragraph 2, 3 and 4 set out the nature of the mark, the subject of the appeal. Paragraph 2 makes clear that the mark was denoted as a mark that consists exclusively of one or more colours. Paragraph 3 sets out the pictorial representation, albeit in black and white, and then paragraph 4 sets out the written description that accompanied the pictorial representation, provided that the trademark consists of the colour dark purple with a Pantone code applied to a significant proportion of an inhaler, and the colour light purple with a different Pantone code applied to the remainder of the inhaler. The defendant was accused of infringing that mark, and you see the alleged infringing product at paragraph 8. And as part of the counterclaim, they argued that the mark was invalid because it covered a multitude of different forms and so was not capable of being represented graphically as required by the legislation. That's summarised in paragraph 9. Then the question for the court is summarised at paragraph 11 of the judgment on page 39. And Lord Justice Kitchen, as he then was, then sets out the legal framework from paragraph 12 onwards. And again, referring, so here he refers to the equivalent article of the trademark regulation, which is consistent with section 1 of our Act. The learned judge talks about the case law from paragraph 21, and the first case he refers to is Libertal, which is the first one that we addressed in our skeleton, and he cites the relevant part of the Libertal decision in his paragraph 21 on bundle page 41. The Libertal case was a colour mark case. It concerned an application to register the colour orange for various telecommunications goods and services. And as the judge explains at paragraph 21, there was no reference to any colour code in the application. It was just literally a card showing a colour orange on it.
Well, together with the word orange.
Together with the word orange, indeed. And for our purposes, I think we can focus on paragraph 29 of the Libertal decision, as it's quoted on page 41. It provides that in order to fulfil its function, the graphic representation within the meaning of Article 2 of the directive must be clear, precise, self-contained, easily accessible, intelligible, durable, and objective. So that is the starting point of effectively the test which the court considers for the purposes of assessing whether a sign is capable of graphic representation as required by section 1. The second case which the learned judge referred to is Heidelberger, which we also address in our skeleton. This was another colour application, and the nature of the mark is summarised at paragraph 23 of Glaxo, which is bundle page 42. And what my lords and my lady will see there is that the mark in issue in that case related to the colours blue and yellow, and the application comprised a rectangular piece of paper, the upper part of which was blue, the lower part of which was yellow, and it was accompanied by the description which read, "The trademark applied for consists of the applicant's corporate colours, which are used in every conceivable form, in particular on packaging and labels. The specification of the colours is," and it gives the two Pantone colours, one for blue and one for yellow. The Court of Appeal, in its summary of the Heidelberger decision, don't identify the goods for which the application was made, but it was a list including adhesives, solvents, paints, and so on. Nothing turns on that. At paragraph 25 of Glaxo, Lord Justice Kitchen first refers to paragraph 25 of the Heidelberger decision, which makes clear that a graphic representation must enable the sign to be represented visually, particularly by images, lines, or characters, so that it can be precisely identified. And he gets that from paragraph 28 of the Libertal decision that you see just on the previous page. So that was the basis of paragraph 25 of Heidelberger. And then he goes on to quote paragraphs 27 through to 31, And perhaps I could just ask my lords and my lady to read paragraphs 27 to 31 of Heidelberger just very quickly. Thank you. So what these paragraphs of Heidelberger are doing are explaining the reasons why, from a sort of policy perspective, it's necessary for a mark to be capable of being represented visually by images, lines, or characters. And there are effectively three reasons or objectives. The first is to allow the competent authorities to know what the sign is for. To know what the sign is, sorry.
Yes.
For the purposes of examination and registration. The second is to allow economic operators to ascertain the rights of third parties. And the third is to ensure that the sign can serve its primary function as a trademark, namely to indicate origin. And we refer to those in our skeleton at paragraph 17. And I should just say there's an error in the first sentence of our paragraph 17, where it talks about, so this is core bundle, tab 6, page 35. And I apologise, it talks about the three conditions in the first sentence, whereas strictly it's actually only the second condition, because that's what Heidelberger is talking about.
Well, but again, can I ask a question about that?
Yes.
Because certainly most of the reasoning seems to refer to the second condition.
Indeed.
But then when you get to the conclusion at paragraph 42, which is quoted in paragraph 27 of Glaxo,
Yes.
what they say is that colours, etc., may constitute a trademark for the purposes of Article 2 of the Directive, where, firstly, it has been established that in the context in which they are used, those colours or combination of colours in fact represent a sign. And then secondly, the application registration includes a systematic arrangement associating the colours concerned in a predetermined and uniform way. So the conclusion refers to the need to comply with the first condition as well as the second condition.
Yes, I think my lord is absolutely right. The error I was correcting in my skeleton was that the paragraphs 27 through to 32 are paragraphs that are engaging the second condition, and they set out the reasons for the requirement, which is the second condition. So all I was saying was that those paragraphs are specific to the second condition.
Okay.
And then in paragraph 35 of Heidelberger, which is set out at paragraph 26 of the Glaxo decision, this is where the Court of Justice give their reasons as to why the application in that case failed to meet the requirements of the second condition. And they say there that such representations would allow numerous different combinations which would not permit the consumer to perceive and recall a particular combination, thereby enabling him to repeat with certainty the experience of a purchase, any more than they would allow the competent authorities and economic operators to know the scope of the protection afforded to the proprietor of the trademark. So as my lords, my lady can see there, what the Court of Justice are doing are identifying two problems with the mark before them. The first is that the numerous different combinations inherent in the mark did not allow the consumer to perceive and recall a particular sign so as to enable him to repeat the purchase experience with any certainty as to origin. And the second was because neither competent authorities nor economic operators could ascertain the scope of protection afforded by the mark. But it's important to note in our submission that the Court of Justice doesn't say that numerous different combinations per se, which are not visually illustrated, is problematic. On the facts, the reason the application was problematic was because the combinations prevented the sign from serving its origin function and prevented the relevant public from understanding its scope. So the reasons were specific to the facts, but it's not authority for a proposition that different combinations which are not visually illustrated is problematic per se. The next authority which Lord Justice Kitchen addresses is Dyson. I'm going to skip over that for now, if I may, because I'm obviously going to come back to Dyson separately when I consider ground one. And I will spend a little bit of time on it in that context. And the learned judge in Glaxo simply just quotes an extract from Dyson without undertaking any analysis about it. He then addresses the Nestle decision. This is at paragraph 30 on page 44. And we addressed this in our skeleton at paragraphs 28 to 30. That case concerned an application for the colour purple in the form set out at the top of bundle page 45 of the Glaxo decision. You see the appearance of the application was the colour in the form of a rectangular shape, accompanied by a written description which provided the colour purple with the Pantone as shown in the form of the application applied to the whole visible surface, or being the predominant colour applied to the whole visible surface of the packaging of the goods. Lord Justice Kitchen set out Sir John Mummery's summary of the principles, which we also cite in our skeleton, and which the judge in the court below set out in her decision. And the learned judge in our case accepted our submission that Sir John Mummery's summary did not say that a mark that permits any degree of variation is necessarily invalid. That's in the judgment at paragraph 126. It's only if the variation leads to a multitude of different appearances that would create problems for registration or give an unfair competitive advantage that the mark is problematic. Problems for registration will occur where the mark is incapable of conveying clear and precise information. And an unfair competitive advantage will occur where the scope of protection is unclear, so that competitors cannot be certain what the mark covers. The other relevant part of the Nestle decision is paragraphs 51 and 52, which Lord Justice Kitchen quoted at paragraph 32 on bundle page 46. And if I may ask the court to read paragraph 32 in the quoted paragraphs.
Yes.
So it's clear that a mark will be problematic if it does not display or describe the variations in a specific and precise manner. The variations must be ascertainable either from the picture or the description or both. If the relevant authorities and economic operators cannot work out the variations, then the mark is not clear and precise. That is reinforced by what Lord Justice Kitchen says himself at paragraph 35 on bundle page 47.
And just to be clear, in these paragraphs of the Nestle decision, they're looking at the first condition. At least it picks that up, doesn't it? Multiplicity of signs.
Well, it's looking at both the first and the second condition in my respectful submission. Because it's the second condition that engages the requirement that the sign is clear and precise, and is one that enables both the registrar and competitors to understand the full scope and extent of registration.
Well, maybe it illustrates that I find it quite hard, speaking for myself, to see that the so-called first and second conditions are entirely independent of each other, and maybe that's picked up.
Yes.
Yeah.
Yes. I understand the sentiment my lady is putting to me. It is quite difficult. And indeed, there is ultimately one statutory test in section 1. It's just that it's convenient to break that down.
Well, yes, the second condition describes the first. It's a sign which is capable. But here, the point is made that it is a multiple of signs.
The point is made that it's a multitude of different visual forms, indeed. But in my submission, one's got to be really careful in understanding that it's not sort of multiplicity per se that's the problem.
Well, is that right? Because isn't that one of the issues we have to consider? So let me be clear. Is it your submission that if the registration covers a multiplicity of signs, but you can tell from the representation what they are, then it's unobjectionable?
No, that's not quite my submission. My submission is that if the registration permits variation to the sign, but in circumstances where the consumer still sees one sign, that is permissible. And so part and parcel of this, and it may be a point of semantics, is whether one calls it a multiplicity of signs or different variations of the same sign.
Well, I think that may be the key point. I think the argument against you would be that it's not pure semantics.
But and I'll come on to this when I develop our grounds of appeal. But in relation to the fourth ground, we say that the judge failed to understand this point in the context of whether what you're looking at are different signs or variations of the same sign. And you understand that you're looking at variations of the same sign in circumstances where the consumer perceives and based on their imperfect recollection is able to recall
So that's
a single
ignoring
sign.
the competent authorities and ignoring the economic operators. So that's collapsing the three tests down to one.
We're not ignoring them. I don't intend to ignore them. They are also capable of perceiving and recalling variations of the same sign. And for this purpose, to count as the same sign, the mistake we say, and again I'll develop this in due course, is it's not about visual differences. in the sense of inherent within the trademark system, you're going to get visual differences. But what's important is understanding the consequence and effect of those visual differences in terms of whether or not they are either A, make it impossible to define the scope and precision of the mark, or B, make it impossible for the consumer to repeat the purchasing experience.
Well, can I approach the question in a different way? How in your submission, when we're considering the first condition, do we differentiate between something which is seeking registration of a single sign and something which is seeking registration of a multiplicity of signs?
Well, I think the answer may be that, and it comes back to my lady's point, that addressing what the sign is as part of the first condition feeds into the second condition, and it's difficult to separate them out.
No, but this is why I asked my earlier question, because you can envisage, in principle, a graphical representation that would be perfectly clear and precise, but would embrace thousands of signs. Or, as you would argue, thousands of variations upon a single sign. And the question is, well, how does one determine whether, in such a case, it is 1,000 variations of a single sign or 1,000 different signs?
And the answer may be there are 2 points. The first is it depends on properly identifying the subject matter of the sign. And the second is it depends on the origin message. And those are effectively the 2 parts of the second condition, the condition that the mark is capable of being represented graphically. In order to satisfy that condition, one has to understand what the subject matter of the sign is. And as long as the subject matter of the sign isn't subject to variation, the variation that is permitted within the trademark system isn't problematic. Let me illustrate the point by way of example so you understand what I'm trying to say. Take a device mark, which is registered in black and white. It's common ground, as a point of law, that by virtue of that registration in black and white, it covers all colours.
Yeah, but that's a question of scope of protection. It's not a question of what the sign is. The sign is only one sign. It's clear and unambiguous. It is singular. The fact that it has a scope of protection, which is not restricted to monochrome, is a different question. It's a question of the level of abstraction of the sign. The sign is a device represented in monochrome. Likewise, a word. The word, what is the word.
Yes.
That's the sign. There is only one sign. Again, the scope of protection covers different typographical representations, but that's different.
Well, can we try and apply? I would be assisted by trying to apply that to the facts of this case.
Yes.
So, can you answer your own questions? How do you describe the subject matter of this?
So if you take the tracksuit top mark,
yes,
because that was the one that the judge focused on primarily. So the subject matter of that sign is 3 stripes, equally of equal space, equal width, the same colour against a contrasting background applied to the outer lateral surface of the sleeve of the garment. In circumstances where the length of the stripe takes up 1/3 or more of the length of the sleeve.
Yes, I thought that would be your answer. And effectively, you say that the purpose of the legislation is served because the origin message is clear.
Indeed.
And you would distinguish the other cases in the long line to which we've been referred where it's held.
Yes.
Sign was not registrable on the basis that there was not that clarity.
Indeed.
Even where words like substantially
Yes.
were used, because it's different in concept.
Indeed.
So,
Indeed.
I mean, at one level you could say, oh, well, 1/3 or more can't be sufficiently precise if descriptions that include the word substantially have been held not to be. But I suspect there's rather more to it than that.
Yes, and
Looking at the facts of the actual case and in trying to work out how to distinguish the cases, I think you would place a lot of emphasis, as I understand it, on the origin message.
yes,
Point.
and the fact that the words 1/3 or more are clear. So when you look at the words 1/3 or more in conjunction with the pictorial representation, there's no doubt as to what it means. And indeed, that's clear from the judgment itself.
Right, and you would contrast the Nestle case in what way?
Well, because
For
Nestle,
example?
just by way of example,
Yes.
Nestle, because it was just a rectangular block of colour with a written description which allowed for that colour to be applied predominantly in circumstances where it isn't clear what predominantly means. It leaves an open-ended scope as to the ambit of that mark and its subject matter.
As
So-
I understand it, the commentary and the judgment said, well, predominantly may cover the proportion of the surface area, but it could cover other things such as apparent prominence.
Quite right. Indeed, my lady recalls it perfectly. And that was the vice with that mark, is that you couldn't sort of draw out the four corners of the mark in terms of its scope, so as to be able to say that it was a mark that satisfies the requirements of clarity and precision. But by contrast, with our marks, everybody knows what 1/3 or more means. It's a mathematical concept. You know precisely what 1/3 or more means. And so there isn't any question as to the clarity and precision of the mark and what its scope is. Point one. And point two, it's a mark which enables the consumer, with their imperfect recollection, to recall a single mark for the purposes of it performing its origin function.
Thank you.
Ms. May, I know you're trying to make your way through the law in order to get to
Yes.
your arguments. You're picking up some of the arguments as you go along, and I don't want to hamper you further, but there was just one statement that you made a moment ago that I just want to check with you, which is to do with the issue of variations, which you said must be ascertainable from the picture, the description, or both. That may be correct, but would it be pedantic to say that actually it has to be clear from, if there are both a picture and a description, from the combination of the two? Because otherwise you can have an argument that it's clear from the picture, and somebody else says, but it isn't clear from the description, or it's clear from the description, but it isn't clear from the picture. Surely, if there is a picture and a description, then part of the argument in this case is that you can't be cherry picking which bit you like and which bit you don't like in order to either attack or protect. So actually, would a more correct statement be that variations must be ascertainable from both
Yes. So
together?
So my lord is absolutely right. And there are just a couple of points to say in answer to my lord's question. The first is, the reason I said it the way that I did was because of what's written in paragraph 51 of the Nestle decision, which is cited on page 46
Yes.
of Glaxo. And as you see in the second sentence, it says, if the colour purple is less than total, as would be the case if the colour is only predominant, the application would cover other matter in combination with colour, but not graphically represented or verbally described in the specific, certain, self-contained and precise manner required.
Yes, I know, but we're not. This is not a statute, and we're trying to understand what the actual situation is rather
Yes.
than simply following.
Quite right.
So,
But
the answer is you can't have a situation where there is inconsistency between the two and either benefit from it by looking to one rather than the other.
Indeed, and it was common ground before the judge that the law is clear that the pictorial representation and the written description must be consistent.
Or put it another way, you've got to read them together.
You've got to read them together. Yes, you've got to read them together. And obviously, we say that in so doing, the reasonable reader will look to read them together in a way that they are internally inconsistent. And one of the issues that the judge...
Inconsistent.
I'm sorry?
I think you mean inconsistent. You inadvertently said inconsistent.
I'm sorry, I mean consistent, yes. We say the reasonable reader will read them in a way that is internally consistent. But one of the problems that we say with the judgment was that the judge did quite the opposite. The way in which she addressed the written description, this is our second ground, is that she read into the written description a variation that wasn't hinted at in that written description, and by so doing read into the registration as a whole an inconsistency that wasn't there.
Okay, well now we'll try and let you get on.
Thank you. So I think I was just in black, so I've just drawn my lords and my ladies' attention to paragraph 35 of Glaxo, and just to pick up paragraph 36 as well, where the judge, Lord Justice Kitchen, makes clear that the reason for these requirements for condition 2 relates to the fact that the mark must be perceived unambiguously so as to fulfil its function as an indication of origin. And I don't think we need to spend any time on the facts of the case itself, but just a couple of other points just to draw the court's attention to in relation to this decision. The first was I was just going to show the court the point about the definition of graphical representation, which, sorry, I just lost the paragraph in my note. It's paragraph 34 on page 47, and it's in the middle of this paragraph. Sorry, at the bottom, the last sentence of the paragraph. This is where the court makes clear that the graphic representation therefore encompasses both the visual representation and any verbal description. And the learned judge says the same thing again at paragraph 63 on page 54, first sentence. And at paragraph 64, this is where he emphasises the point that my lord has just put to me about the importance of reading both the written description and the pictorial representation together. You see that in the second sentence about focusing on the graphical representation as a whole. So just very quickly, that's been a very quick canter through the relevant authorities. The only other one just to pick up on is the Steele decision, which we referred to in our skeleton. This is in the authorities bundle JA2, and it's at tab 12. And we addressed this in our skeleton from paragraph 21.
So this is a post-Brexit decision and therefore persuasive only.
That's absolutely right, my lord. But the reason, just to draw it to to the court's attention, is twofold. Firstly, it's an application of the same principles, and secondly, it of all the authorities before the court, in our submission, it's the one that's closest to the position marks of the type that are under consideration in our case. So the application was for a colour mark comprising the pictorial representation at paragraph 2, which is bundle page 221, together with the written description in paragraph 3. The colour orange applied to the top of the housing of the chainsaw, and the colour grey applied to the bottom of the housing of the chainsaw.
It's interesting to non-specialists to see how very unreliable reproduction is.
Yes.
There's nothing. Doesn't look anything like either of the colours that are in fact used.
No, but that's one of the reasons why Pantone numbers are given to.
Exactly, but it makes you wonder why colours are ever used, because they simply can't be reproduced accurately.
No. So the General Court considered the relevant authorities in its analysis, and we can pick it up, please, at paragraph 37 of the decision, which is bundle page 225. And if I might ask the court, please, to read paragraphs 37 to 41 very quickly.
Yes.
Thank you. So there are just a number of points to emphasise from these paragraphs. The first is that the mark in issue clearly covered undepicted forms. Indeed, there's no visual representation of the chainsaws at all. Second, moreover, the mark clearly covers chainsaws with a variety of different shapes. Third, however, this did not prevent the mark from providing a single origin message. Fourth, in addition, even though the shape of the housing could change, the information provided by the visual representation and the written description together were sufficient to enable the relevant public to perceive the mark as a whole in a precise and uniform way. And it may be useful just for the court to see what these chainsaws looked like. There are some images, in fact, just in the next tab, tab 13, because they're reproduced in the cancellation division decision on bundle page 232. So you see there some examples of different chainsaws to which the mark was applied.
To what extent the bottom right one there varies from the others in terms of the colour.
Yes.
But as I understand it, and correct me if I'm misunderstanding, these illustrations were not before the General Court in the case point.
I think my lord is correct on that, and they're obviously not part of the registration itself. So that was all I was going to say on the points of law, just conscious as I am of time. And unless I can assist my lords and my lady any further on the authorities, I was going to move on to the judgment under appeal, because some certainly in relation to Dyson specifically and Zinger, I'm going to talk about that in the context of our first our ground one. So the judgment under appeal is at tab 10, and I trust the court has had the opportunity to have a look at it. And my lords and my lady will have seen that after a general introduction and a section addressing the witnesses, the judge turns her mind immediately to the question of registrability. So that's from paragraph 112 on bundle page 108. And she sets out a summary of the law. And we don't take issue with the summary, save in relation to Dyson, which I'll come back to. And then she addresses Thom Browne's specific points of attack. And in that regard, she deals with and rejects the alleged lack of clarity in respect of the colour marks, in respect of colour, sorry. And she does that for all of the marks together in one go up front. That's at paragraph 147 to 153, before she then embarks on an analysis with respect to each mark separately. And for our purposes, we can pick it up at paragraph 175, which is the tracksuit mark 588, bundle page 123. And my lords and my lady will have seen that the judge focused her analysis on this mark and then applied it to the other 5 marks in issue on this appeal. And if we could pick it up at
What she says she's doing, doesn't it? She doesn't say, I mean, maybe I've missed it, but I don't recollect her saying, and for the reasons I gave in relation to 588, this one's invalid too.
Yeah, my lord, I think she does do that. Just by way of example, at paragraph 213, now I've just picked that up by way of example. Last sentence, I repeat all the other points I've made in respect of tracksuit top 588. And my learned junior can give me the references, but from memory she does that for all of the marks.
But she also gives them independent consideration.
She does. And another example, 235, last sentence. She does, but she doesn't give them the same level of detail because she's carrying
Thank
across.
goodness for that. It's already a 100-page judgment or something. Yes.
So back at paragraph 180 on bundle page 124, this is where the judge summarises Thom Browne's main objection concerning the words 1/3 or more, and the fact that it contended that those words are uncertain, imprecise, they're no better than the words substantially the whole length, and they say it necessarily contemplates a multitude of different forms, the sign being capable of being represented in various different ways. And then at the next paragraph, 181, she makes a number of important findings. Perhaps I could ask the courts to reread paragraph 181.
Yes.
So there are 4 important findings in this paragraph. First, the learned judge notes that whilst the written description does not refer expressly to the pictorial representation or illustration, she must read them together, and we agree. Secondly, she acknowledges that the illustration is intended to show the position of the mark on an upper garment with sleeves. Again, we agree. Thirdly, she says that the pictorial representation shows the position of the mark to be on the outer lateral surface of the sleeve, where the sleeve does not include the cuff. we agree. And pausing there, we note that this finding is consistent with what the judge had said back at paragraph 142 sub F on page 117, to the effect that the purpose of the illustration is to show the specific position of the mark. Then the fourth finding in para 181 is that she says, absent the words running along 1/3 or more, the mark would be limited to the pictorial representation. And the effect of that finding is that it is only the words running along 1/3 or more which inject variation into the mark. Then at 183, the judge looks at the cancellation division decision, which I'll come back to in just a moment. And then at 186, she starts by reminding herself that variation per se is not fatal to registrability. 187, she says that she's found the decision a difficult one to reach on validity, not least because it hasn't been the subject of judicial scrutiny before now. And then at 188, this is where she starts by rejecting the reasoning of the cancellation division decision. That decision is in the bundle, it's JA2 tab 13. And if I may ask the court to turn to it, please. And for our purposes, it's sufficient to go straight to the reasoning on page 237 and 238. Unfortunately, the decision doesn't have any paragraph numbers. It's a bit more difficult to navigate.
Sean, that's the vest mark. Do you mean the tracksuit top mark? Tab 13 is the vest mark.
Oh,
decision.
yeah, sorry. I don't think it matters. I've done my notes on the vest mark decision. It was the first one in the bundle. It's the same wording across the decisions.
But we have it in the next tab, it's tab 14.
Do. Yeah, we do. So I'm grateful to my learned friend. So it is the equivalent paragraphs are on page 249 and 250, also highlighted. And if, in fact, if I could ask the court firstly to have a look at the bottom of 250, there are the 3 paragraphs at the bottom of that page. Those haven't been sidelined, but I'd be very grateful if the court could read them quickly, because those are the paragraphs that the judge engages at paragraph 188 of her decision.
Discussing the Red Bull case.
Yes.
Okay.
Right, so the key point is number of possible variations remains rather limited.
Yes, indeed. And the judge rejects that at 189 of her decision. And then at 190 of her decision, she addresses the other part of the reasoning, which is blacklined, which is page 249 to 250. what the learned judge says at 190 is that she rejects that reasoning too. And she says, she identifies that as the core of the decision, and she rejects the reasoning because she doesn't agree that the scope for variation in the length of the mark is limited, or that the resulting flexibility in appearance is acceptable. In her view, as she sets out in paragraph 192, the cancellation division didn't pay sufficient attention to what she said were, quote, significant differences in appearance. You see that in the last sentence of 192, which she said were caused by the fact that the starting and finishing point of the stripes isn't fixed. And the problem with that paragraph, we say, is that at this point the judge doesn't explain why the visual differences are significant or how that matters to registrability. And that's what I will return to when I address the fourth ground. But just walking through the judgment quickly, what she goes on to do at 193 is to say that once one accepts that the pictorial illustration can only be an example, and that the length, the starting point and the finishing point of the three stripes may change, it's difficult to see why the actual position of the stripes running along the sleeve may not also change. There's nothing in the description to indicate that the stripes are to be on the outer lateral side of the sleeve as opposed to, say, the underside of the sleeve. And there are a number of problems with this paragraph, which forms the basis of our ground 2, which is the ground I wanted to address you on first. So we say that this paragraph is fundamentally flawed.
Do you want to finish going through the judgment before you get to your grounds?
Yes, by all means.
Well, I mean, would it take your own turn? I was just wondering.
I was just going to pause here to explain it, our problem with 193, because I think it feeds into how you read 194 and 195.
Okay.
So the problem with this paragraph, as we see it, is as follows. First, it's clear from the way that the judge presents her reasoning in 193 that she's focusing on the description alone. But we say that's an error of principle, as I've shown my lords and my lady and the authorities this morning, and indeed as the judge herself accepted back in paragraph 181. She should have considered the description and the pictorial representation together.
Sorry, but she does that expressly, the very wording. The pictorial illustration can only be an example. So she's referring to the pictorial illustration. Where is she saying that she excludes that from her consideration and is solely focusing on the words?
In the next sentence, where she says there's nothing in the description to indicate that the stripes are to be on the outer lateral side of the sleeve, as opposed to, say, the underside of the sleeve.
Well, that's a true statement, isn't it?
Well, it is in isolation, but it's not true when you look at the description and the pictorial representation together, because the pictorial representation makes clear that the stripes run along the outer lateral side of the sleeve. Indeed, the judge makes that finding herself at paragraph 181. And she also...
Well, she doesn't quite make that finding. She says, absent the words running 1/3 or more, it would not be difficult to interpret it as being restricted in that way. But anyway.
I think it's the sentence before, my lady, the one that starts, thus it shows the three stripes running the full length of the sleeve, and also shows that the stripes are located on the outer lateral surface of the sleeve. Do you see where I am in the middle of 181?
Yes, but you then need to read that with the next sentence. Absent the words, etc., not difficult to interpret this mark as restricted to what is shown in the illustration. So, of course, if you're restricted to what's shown in the illustration, necessarily it's the outer lateral part of the sleeve. There's no inconsistency between that and what she says in 193. where she makes the point that as soon as you know that you're not restricted to what's shown in the illustration, but on the contrary, there's variation, the question is, where do the variations stop?
But the variations can only, the answer to that question is that the variations stop within the ambit of the mark as a whole. And so you take the mark as a whole, your starting point is the pictorial representation, which makes clear that the position of the stripe is on the outer lateral surface of the sleeve. And as the judge herself says at paragraph 181, then the only scope for variation comes from the wording. And when you look at the written description, the only variation that is permitted by the written description is to vary the length. And so it's simply not open to the judge in our respectful submission to say that there is any further variation beyond what is permitted by the written description in terms. And that's the error that the judge has made. What she's done is she's effectively read into the mark as a whole variation which isn't hinted at in the written description or the pictorial representation.
I mean, this is, as it seems to me, the argument on 193 seems to be an argument that you take, but it doesn't attack the fundamental point, which the judge seems to be making at the end of 192. She's thrown this point, whether it's a good one or a bad one, in on top of her main argument, which is that there are significant differences in appearance caused by the fact that you can move the stripe up and down the sleeve and change its length within limits. So I perfectly follow your argument, if I say so, underground too, but it wouldn't be enough to get you home on its own.
Well, in my respectful submission, it's certainly enough for this court to undertake the analysis itself.
I was going to ask you at some point as to what the standard of review is that we're applying, because speaking for myself at the moment, I would readily accept that if the judge has misdirected herself in law or set herself a wrong test, then that's a matter that it's either right or wrong. But when one starts looking at pictures of stripes on sleeves, I have some difficulty with the idea that there's just one right answer, and that we, sitting here and looking at a fraction of what she looked at, are in the same seat as she is. But could you help us as to what the correct approach ought to be?
Yes, so in relation to this ground that we're dealing with, and paragraph 193, our submission is that the reasoning in that paragraph is firstly based on a lack of consistency with her earlier findings at paragraph 181 and 142.
Yes, I wasn't so much wanting to focus. I mean, you might want to use it as an illustration.
Yes.
What is the standard of review that we apply to what, as I've said, appears to me to be an evaluative decision of what something looks like and what it's going to be understood as?
I'm sorry, I misunderstood the question. So the lifestyle equities authorities in the bundle,
right,
and that makes clear that it's open to this court to undertake the exercise afresh in circumstances where the court below has based a decision.
Right, sorry to interrupt,
Yes.
but that seems to be clear. You seem to be accepting the proposition advanced by the respondents that this is a multifactorial evaluative decision akin to an assessment of likelihood of confusion or obviousness.
Well, in relation to this particular ground,
Well, no, it's before we get into the grounds. It's got nothing to do with the grounds. It's to do with the nature of the issue.
yes,
So the nature of the issue here is, do these registrations comply with the definition of a trademark in the legislation. It's as simple as that. Now, one view of that is it's a binary question. There's a right answer and there's a wrong answer. The other view is no, it's not. It's an evaluative decision because, as we see when we look at the facts of the cases, the answer is not unambiguously clear. And therefore it is an evaluation, even if it's not quite so many factors as one has for obviousness or likelihood of confusion. So the question is, what's your submission?
I'm sorry, I misunderstood. It is an evaluative. It is an evaluative exercise, and
so that you accept the applicable test is lifestyle equities.
Yes, we do.
Okay, that's helpful.
But the point, the reason why lifestyle equities, the reason why we sort of get over that sort of threshold requirement, if I can put it like that, it is because when you look at paragraph 193, you see that the judge reaches a conclusion which is inconsistent. It's inconsistent with her findings at 181 and 142, subparagraph F, because in those earlier paragraphs, she has made a finding that the position of the stripes is determined by the picture. And yet when she gets to paragraph 193, she goes against that earlier finding in expressing her opinion that because the written description allows for a variation in length, somehow all bets are off, and you can move the position of the stripes as well and put them anywhere on the sleeve. But there's nothing in the picture or the words that tell you can do that, and to reach that conclusion is inconsistent with her previous finding that the position of the stripe is on the sleeve.
So just to be clear,
yes,
do I understand that you would accept that the words would encompass stripes on the underside of the sleeve, but you say the picture excludes that?
No, I say they both exclude it.
Well, which words exclude putting stripes on the underside?
Oh, I see. Well, it's the words and the picture together. It's the graphical representation as a whole.
So you accept, to be clear, that the words embrace the possibility envisaged by the judge, if taken on their own. But you say, once you look at the picture, you understand that that's excluded. Indeed.
And it's not legitimate to look at the words on their own. That is an error of principle. And so as a consequence, the judge failed to take into account a material factor, namely the information that you get from the pictorial representation. And she failed to approach the mark as a whole, as the authorities require her to do. And there was a sort of fundamental gap in her logic, because just because the written description permits the length of the stripes to change, it doesn't mean that the position of the stripes, which are limited.
Can I ask you this question then?
Yes.
In your submission, does this registration encompass stripes which covered the cuff?
No, the cuff isn't included because you can see where the stripe ends on the stripe is on the sleeve, and the cuff isn't part of the sleeve, nor is the collar.
Right.
But all I was trying to submit.
And how does one know that? Never mind the collar, but in the case of the cuff, how does one know that that's excluded from this part being part of the sleeve?
From the image, from the pictorial representation, which you see on page 123, for example.
Yes.
So what I was trying to submit to the court was that there's a fundamental gap in her logic, because it's a non sequitur to suggest that just because the written description permits the length of the stripes to change, it somehow therefore also allows the position of the stripes to move from the outer lateral surface where they are depicted in the pictorial representation to another part of the sleeve. One simply doesn't follow from the other.
Right, so that's ground 2.
Yes, and we say if the judge had considered the pictorial representation and written description together, as she should have done, she would have interpreted the mark in the following way. First, the stripes are positioned on the outer lateral side of the sleeve. That's consistent with what she holds at paragraph 181. Second, the length of the stripes can vary. That's clear from the written description. Third, the starting and finishing points of the stripes can also vary. That's also clear from the written description. And fourth, nothing else can change from the pictorial illustration of the mark. And that's clear from the graphical representation as a whole and is consistent, we say, with how trademark systems how our trademark system works. Because one of the problems with 193 is that the judge seemed to think that because the mark didn't have a statement to the effect of nothing else can change, she was entitled to read in any other variation she wanted to. But it's not part of our trademark system to require a trademark to have an express statement to the effect that nothing else can change.
Sorry, I don't understand that. Is it your submission that you're prevented from putting exclusionary words in the written description?
No, I'm saying that one of the problems with paragraph...
The wording of the description you accepted earlier was solely at the choice of the applicant. So the applicant could have put in negative criteria as well as positive criteria.
Yes, but the point I'm making is a slightly different one, my lord. I'm picking up the fact that the judge says at 193 last sentence, there's nothing in the description to indicate that the stripes are to be on the outer lateral side of the sleeve. So it's almost like she's requiring there some kind of express statement to say nothing else can change. Whereas when you look at the description and the pictorial representation together, the limits of variation that's permitted by the sign is clear. So the four things you get from interpreting the pictorial representation and the language together: the position of the stripes, that they can vary, that the length can vary, the starting and finishing points can vary, but nothing else can change, are the 4 points which the respondent accept. If they were written down, then these marks would not be objectionable. That's my learned friend's skeleton at paragraph 58 to 59. Which is bundle page 74. So his submission is, if those 4 points were written down, the marks wouldn't be objectionable. And apparently the only problem with the registrations is that those 4 points aren't written down. We don't accept as a point of principle that the information that's listed 1 to 4 in paragraph 58 must be in the written description in order for it to be clear. It's just as legitimate to get that information from the graphical representation as a whole, including taking into account the effect of the pictorial representation and the wording together. And those 4 points that are listed in paragraph 58 are 4 points which, on a proper interpretation of our marks, you get in any event by virtue of the combination of the information in the pictorial representation and the written description together. And the fact that that information doesn't have to be written down is consistent with the approach that His Honour Judge Hakon took in the Baybeck case, which is in the authorities bundle. And I can show my lords and my lady the point very quickly. It's in JA1 tab 6. the mark in issue in this case is shown on paragraph 120, page 120, paragraph 4 to 6. It was a device mark limited to certain colours. And the issues...
Yeah, and as you mentioned earlier, we've got elsewhere in the bundles the colour version.
We do, yes. And then the issues before the judge, we can pick it up at paragraph 81, where the judge sets out the issues before him. That's on bundle page 136, where he explains that the argument is about inconsistencies between the visual representation and the written description, as well as ambiguity and alleged multitude of forms. And then the key paragraph for our purposes is paragraph 87 on bundle page 137. And if I could just ask the court, please, to read that paragraph to themselves. So the court rejects the idea that everything must be written down, with no detail left unsaid. Instead, the judge holds that the reasonable reader can understand the scope of the mark by reference to the written description and the visual representation together. Not all details will be stated or reproduced in them both. So it seems that the respondents are just being anxious pedants in requiring their list of the 4 points at paragraph 58 of their skeleton to be written down, when those 4 points can all be ascertained from the graphic representation as a whole. And on that basis, the marks are unobjectionable. So we say that paragraph 193 is fundamentally flawed for the reasons I've given: inconsistent in approach, not supported by authority, and a fundamental gap in logic. And that is reason alone for this court to consider the question afresh.
Sorry, I'm coming back to the same point that I made before, which is that assuming that you're right about 193, which you've taken quite a lot of time on, I'm not clear in my own mind that that gets you far enough, because it might be said that 193 was a sort of au revoir by the judge to the point which he had just made in the previous paragraph, which is a much more fundamental point. So I just give you an opportunity to explain why that thinking is misplaced.
Well, it rather depends on how one reads 194 and 195, I think, which I'm going to come on to next, because this feeds into the next ground.
All right, well, I'm not pressing you for an answer. I just wanted to alert you to the analysis that I was conducting.
Thank you. Well, I'll try and address it in the context of what I say in 194 and 195. So these are the paragraphs where we say the judge wrongly adopted the respondent's argument based on Dyson, to the effect that just because the written description of the mark allowed for unrepresented signs, and hence the pictorial representation was only an example, the mark necessarily lacked clarity and precision.
Right, so we're on 194, 195, and on which ground or grounds?
This is ground one.
Ground one, thank you.
So what I want to do in relation to this ground, if I may, is start by showing my lords the Dyson decision and explaining its ratio. Secondly, to show my lords how the judge misunderstood the effect of the
Just so
Dyson
as I
stripe.
can see where we're going here.
Yes.
As I understand it, this is all focused on the last sentence of 194. And the question I would like to ask you to see where we're going is,
Yes.
if one deleted the last sentence of 194, what difference would that make to the reasoning? And how could you sustain ground one on that hypothesis?
My lord, well, it's the second sentence of 194 as well, where she refers to it's only an example, because the
It's
language.
your own case, it's only an example. It's your own case that what's in the picture is only an example, because you make it very clear that you are not restricted to what's shown in the picture. So therefore it has to be an example. So can't be any error there on your own case.
Well, the error in that second sentence is an error of on the part of the judge to question what is covered or what's within the scope of the mark, because she says
But that's other grounds. You've got that. You attack that under other grounds.
Yes.
Ground one is all about unrepresented signs, and your case, as I understand it, is that an error in itself. And that's why I was asking the question that I did, because at the moment I'm struggling to understand the relevance of ground one, because at the moment it seems to me you could delete the last sentence of 194. It would make no difference at all to the substance of the reasoning. 195 would still stand, and ground one would disappear.
Well, I'm not sure that's right, and let me explain why. As I say, there are two ways that you can read paragraph 194. The first way is that the second sentence, where the judge is talking about what she perceives to be a lack of clarity, is based on paragraph 193. So if paragraph 194 is predicated on 193, where the judge has already made an error that she thinks that you can move the position of the stripe so that it's anywhere on the sleeve, you may be able to understand, based on that error, why she thinks the illustration doesn't add any clarity to the scope of the mark overall. But if paragraph 194 is a freestanding point, then the only basis upon which the judge could have reached the conclusion that there was no clarity is because of the unrepresented signs argument, which was the argument being urged upon her by the respondent in the court below. And you see that argument as you walk through the judgment. So the first time it's articulated is that paragraph 139 on bundle page 116. And just for context, what the judge has done by this point is she's given her own understanding of Dyson at 132 sub B on page 114, which I'll come back to in a moment because I think the way she's characterised it is not correct. Then at 135, she accepts our submission that variation per se doesn't inevitably make a mark invalid. But at 139, she identifies a separate argument being pursued by the respondent based on Dyson. And in this paragraph, she characterises the argument as by reference to Dyson being merely, the illustration and Dyson being merely examples of the mark. You see that quoted on the third line. And then if you pick it up about 5 lines from the bottom, she says it's TB's case. The Court of Justice made clear in Dyson that it's not acceptable to have a description which allows for what TB describes as additional unrepresented signs, i.e. signs which are not depicted in the graphic representation, because that representation is merely said to be an example. TB frames this as an additional answer to the permissible variations point. Specifically, TB says that variations are impermissible if they are not depicted and can only be understood having regard to the wording of the description. I shall return to this point when considering the Adidas marks in due course. So she sets out what she understands the argument to be, namely that if you can have variations which are not pictorially represented, your mark is inherently invalid. And she characterizes that as the unrepresented signs, quote unquote, argument. And that is what you see when you look at 193.
Can we be clear as to the relevance of the point?
Yes.
Because it comes back to some of the questions I was asking earlier. Because Dyson is all about the first condition. And it comes back to the question I was asking you earlier as to whether you can have a registration for a multiplicity of signs. And you've given your answer on that already. But the question that rises at this point is, do you accept that it doesn't matter how the multiplicity of signs arises? If in truth it is a registration for a multiplicity of signs, it doesn't matter whether that arises out of the written description or out of the picture, or both.
I mean, that must be right. But obviously we've had a debate about whether it's a single sign, variations of a single sign, and it really depends on how you're defining the sign. The other reason why I say that the judge is using this shorthand of unrepresented signs to refer to the Dyson argument is because of what she says at paragraph 153 on page 117, where she again summarizes Thom Browne's arguments. And you see point 5, she says, many of the marks are objectionable because they contemplate, quote, unrepresented signs, close quote, i.e. a complaint arising by reference to the Dyson. Para 153. 143, I'm so sorry. I'm so sorry. Page 117. Little Roman 5 in the middle. It says many of the marks are objectionable because they contemplate unrepresented signs, i.e. a complaint arising by reference to the Dyson decision.
Yeah, but this is why I asked the question that I do, because I personally speaking for myself, and it's not your fault. Let me be clear, it's not your fault. But I find the language of unrepresented signs unhelpful. The question is, what's the objection? And the objection, as I understand it, is it's a multiplicity of signs, and therefore there's no compliance with the first condition, and that's why Dyson is relevant.
But then the question in turn is, why is it a multiplicity of signs?
Yeah, we go round in circles on that point.
We do. And my lord understands that our submission is that these marks don't comprise a multiplicity of signs. They have variations of a single sign, and that variation is limited to the length of the stripe. So it's effectively the size of the sign on the position of the garment. And that variation doesn't have any difficulty when it comes to clarity and precision, because you totally understand what it means. You understand what it looks like. In fact, the judge herself set it out at paragraph 191. So then the only question is whether those visual differences have any significance.
But you see, this is why I asked you my original question about what the foundation for the reasoning is, because when one goes to 195,
Yes.
this is the passage that I was referring to earlier. I disagree with Adidas that taking the mark as a whole, the relevant public will perceive a single sign with only a limited degree of variation. So the essence of the reasoning is no compliance with the first condition because it's a multiplicity of signs. And then she goes on to talk about a wide variety of different forms. And at the foot of the page, don't consider the public, if exposed to every possible permutation, would see the same mark. So again, and it's even clearer when you get on to 196, does not correspond to one single, clear, precise, objectively ascertainable sign. So It's non-compliance with the first condition. The fact that it's unrepresented isn't the point. And as I say, that's not your fault. That distraction was obviously introduced by your opponents. But nevertheless,
So
the real issue is the one that the judge has actually articulated, isn't it?
well, in my respectful submission, what paragraph 195 is addressing the question of clarity and precision, and whether the sign is uniform and unambiguous, so as to enable the relevant consumer to repeat a purchase with confidence. Sorry, my lord, please just give me a moment. My learned junior is reminding me that one of the other reasons why we know that her decision is limited to condition 2 is because of what she says at paragraph 198. In paragraph 198, she says in conclusion that the mark falls foul of the identification requirements, but the identification requirements are set out in the judgment by reference to the Nestle decision at paragraph 119 on bundle page 109. And the list of issues that the judge is addressing.
Yeah, but the problem with that is that, as I pointed out earlier, Nestle was a case of non-compliance with the first condition. It has to be understood in that context. Moreover, even in that very passage, the 3 conditions are set out.
It's the identification heading and the third point, that's what I'm referring to. That's what the learned judge had in mind when she was talking about identification requirements. Do you see where I am? Subpara 3. And at this point, so what Sir John Mummery is doing is summarising the principles from the case law. So the fact that he's summarising principles that pertain to condition 2 is separate from the point my lord is putting to me, namely the ratio of the decision is based on condition 1.
So your submission is that he's excluding compliance with the first condition when he says that, even though in the next subparagraph 4 he says not satisfied with the mark could take on a multitude of different appearances.
Well,
A multitude of forms on its face, one might have thought, is a reference to Dyson.
So what I'm trying to do is explain why we understood the judge's decision to be anchored in condition 2. And one of the reasons for that understanding is because her conclusion is that the mark falls foul of the identification requirements. And what I'm showing you is where she gets that term identification requirements from, which is paragraph 15, subparagraph 3 of the Nestle decision, based on Sir John Mummery's summary of the cases.
Yes, but this is why we go around and say, I mean, it's not your fault necessarily. I mean, I get the strong impression that there was a failure in argument before the judge to distinguish clearly between the first condition and the second condition, but that's by the by. I may be wrong about that. Maybe you were all deeply clear, and in particular took the judge through the distinction is explained in Zinger. But let's leave that aside. The fact of the matter is we are where we are, and if the decision was solely based on condition 2, you wouldn't need ground 1.
So the answer to my lord's question may come in paragraph 101, where the judge sets out the issues that she's deciding. And 108, sorry, I seem to be numerically dyslexic today. Page 107, paragraph 108, sub 1. that's the issue that the judge is considering.
Absolutely. And that, of course, embraces both first and second conditions. Do they constitute signs? That's the first condition. Are those signs represented with sufficient clarity and precision?
Well, it was certainly argued in the court below by reference to condition 2. And that is what the parties understood was being represented by her issue 1. And that was the argument before the court.
Oh, well, that's a new piece of information to me. So is it your submission, therefore, that in this court, the respondents are disentitled to rely upon condition 1?
If that's the way they are going to characterise their argument, then yes, because that isn't how it was run in the court below. I mean, you see again at para 180, my Leonard Junior, it reminds me, which is where I took the court earlier this morning.
Necessarily contemplate a multitude of different forms. I don't see why that doesn't evoke condition 1, but there we go. You say it's all about condition 2.
So I wonder if I can just ask my lords to look at the Dyson decision, because I think it's important just to be clear about what the ratio of that decision is. It's in the authorities bundle JA2 tab 10. Starts at page 193. The mark is set out at paragraph 10, bundle page 199. There were 2 applications in issue. In each case, there was a written description whereby the mark consists of a transparent bin or collection chamber forming part of the external surface of a vacuum cleaner, as shown in the representation.
Yeah, it doesn't actually set the mark out.
No,
the mark
it
is
doesn't.
set out in zinc.
It is in Zynga, exactly. I'm very grateful, my lord. And Zynga is in the other bundle, JA1, and it's in my lord's first instance decision, which is bundle 1, tab 1.1, and the relevant paragraph 18.
Yeah.
Where my lord set out the images. And hopefully that's in colour as well.
Yeah, and one of the things one needs to understand about this case is that although one reads the words as shown in the representation, it was Dyson's own case that they were limited to the representation.
Yes, and that's paragraph 19 of the judgment, bundle page 200, where that is made clear. And Dyson's position was that their application wasn't limited to the shapes of the cleaners in the pictorial representation. Indeed, it wasn't limited to any shapes at all. The whole point of the application was to obtain a registration in relation to any vacuum cleaner with a transparent bin. So what they were seeking a monopoly over was the mere property of the bin being transparent. And so they were trying to protect a concept a bit like a patent claim rather than a trademark. And it was for that reason that the Court of Justice ruled that the mark or the application didn't constitute a sign at all. And you see that in paragraphs 35 through to 40. But, we say the key paragraph is paragraph 39, where the court makes clear that it's the mere property of the product, which means that the application doesn't constitute a sign.
Now, what about, did you say about paragraph 37? where they say the subject matter of the application of the main proceedings is capable of taking on a multitude of different appearances and is thus not specific.
Yes, but the what that sentence says is in the context of that particular application, you cannot ascertain, the reason you can't ascertain the specificity of the mark is because the scope of the registration is open-ended. And they explain that
Well, it's because, as is pointed out at the end of 36, the representations cannot be assimilated to the subject matter of the application because, as pointed out by Dyson a number of others, they're merely examples of it.
Well, in fact, the explanation of the sentence my lord puts to me at 37 actually comes in the second part of 37, where they point out that the shape, the dimensions, the presentation, the composition will depend on the vacuum cleaner models, and that's going to vary over time into the future as different models are developed by Dyson, and it's also going to vary and depending on technical innovation. So you've got a situation where you've got no idea what the limit of the mark is. You've got no idea what the subject matter of the mark is at all, because you cannot put the transparency as a property into a visual representation or a description, and you can't link it to any particular shape because it's not limited by reference to the shape. And so it's for that reason that you have a totally open-ended registration, one which effectively varies over time as new technological advances come to light.
All right, but what's in your submission is the objection, because we know that the Court of Justice finds that what is sought to be registered is not a sign. Why is it not a sign? Answer, because it's a multiplicity of signs.
No, in my respectful submission, my lord, the answer isn't because it's a multiplicity of signs. The answer is because what is being sought to be registered is a mere property of the product. And that's paragraph 39 of the decision. That's the reason why.
So you say it's perfectly in accordance with Article 2 of the Directive and Article 4 of the regulation to register a multiplicity of signs in one registration.
Well, it comes back to the debate we've already had about what you mean by a sign. But if you take the Steele case that I referred you to,
We're concentrating here on principle, not individual cases. And the answer you gave to me earlier was different. What you said to me earlier was you accepted that you couldn't register a multiplicity of signs. You said that this was not that case. You said that there was a difference between a multiplicity of signs on the one hand and a single sign with variations on the other hand.
yes, and I stand by that.
So do you accept, therefore, that the fundamental principle that we get out of Dyson is you cannot register subject matter which is in truth a multiplicity of signs?
No, I don't. I don't think the judgment goes that far. What the judgment says at 37, with the sentence my lord pointed me to, was where it talks about the multitude of different appearances. The vice in that isn't multiplicity per se. It's got to do with the fact that as a consequence,
Right, so your submission therefore is, as I now understand it, it is acceptable to register a multiplicity of signs because Dyson doesn't prevent it.
well, I'm not sure I have to go that far either, because for the reasons I've already explained to my lord this morning. Our registrations are not attempts at registering a multiplicity of signs. They are permissible variations of the same sign.
So a multitude of different appearances is something different from a multiplicity of signs.
Indeed.
Yes.
Yeah. And it really comes down to whether the visual differences make any relevant difference. And they can either make a difference because they undermine the clarity and precision of the mark, so you no longer know what the scope of the mark is, or they make a difference because they deny the mark the capacity to have a consistent origin message. They deny the ability of the consumer to recollect a single sign for the purpose of repeating the purchasing experience.
Right, how are you getting on?
I am doing all right.
Good. I've obviously been, You've been waylaid, yes.
I need to pick up any last points on Dyson before I move on. If I could just next show my lords what the learned judge said about Dyson at paragraph 132. Subparagraph B, this is bundle page 114. So the problem with this paragraph, as we see it, is that the judge considered that because the Dyson visual representation was only an example, which she observes in the second sentence, she goes on to say, accordingly, the Court of Justice held, as was therefore common ground at the hearing, the trademark application covered all conceivable shapes. And thus, she said, it did not constitute a sign for the purposes of Article 2 because it was capable of taking on a multitude of different appearances. And I hope my lords and my lady now understand why we say that's not the correct characterisation of Dyson, because for the reasons I've just admitted, the ratio in Dyson wasn't that it was a multitude of different appearances that was the problem. The problem was the applications related to a property per se, which wasn't capable of being a sign at all.
It doesn't just stop with the multitude of different appearances, and I understand your argument about that, but goes on to say, and involve a non-specific subject matter.
Yes.
Clearly, when we are considering this, I mean, we're not considering a lengthy judgment of this kind as if it was an exam paper and the judge has to get 100%. It's a question of the extent to which any criticisms that you validly make invalidate
Yes.
her core reasoning. So I think we have to be careful before picking out a certain point and saying, well, I've made that point, without seeing what the whole of the judge's reasoning consists of. So doesn't it go a little bit further in the very last words of Para B in her assessment of Dyson?
Yes, and so I mean, my lord is right, and if we agree that the mark in Dyson pertained to non-specific subject matter, it was a property, not a sign.
Yes.
But where we part company with the judge's analysis is by reference to the multitude of different appearances. So then, just drawing the threads together, when you come on to back to paragraphs 194 and 195 on page 126 of the bundle, this is where we say it was clear that the judge had the Dyson argument in mind, albeit that she hadn't addressed it properly anywhere in her decision. But she seems to be, like I say, there are only two ways of understanding these paragraphs. Either she's basing her decision that the pictorial representation can't provide clarity because of the error she's already made in paragraph 193, or else she is saying that where a mark covers variations that are not depicted, that is a fatal flaw, and will always lead to invalidity. And if that is what she's saying, then that's obviously not supported by the Dyson decision. The case doesn't go that far at all. And nor, in fact, is it supported by the other authorities, which my learned friend relies on in his skeleton at paragraph 50 to 53. In those parts of his argument, he refers to Nestlé, Glaxo, and Red Bull. We've already looked at Nestlé this morning, and there's nothing in that decision which supports the proposition that unrepresented variations automatically lead to invalidity. Indeed, as we looked at this morning, paragraph 51 of the judgment in Nestlé makes clear that variations, it was only because the variations in that case were not graphically represented, as in pictorially represented, or described with any certainty or precision at all. So that case was a decision on the facts that there was nothing in the pictorial representation or the written description to make the scope of the mark clear and precise. And the reader couldn't ascertain the subject matter at all. But by contrast, in our case, for the reasons I've already explained, when you take the pictorial representation and written description together, the reader has certainty as to what the mark comprises. And the point my learned friend gets from Red Bull and Glaxo is that the written description can't be inconsistent with the pictorial representation. We agree, and in fact the judge held herself at 195 that the pictorial representation is not in itself inconsistent with the description. That's the first sentence of 195. And it seems that the only doubts that the judge has about the scope of the mark is based on her erroneous view at para 193 that the position of the stripes are not limited to the outer lateral surface of the sleeve. Once that erroneous view is removed from the analysis, then the mark isn't objectionable.
So that involves completely ignoring what she says in 192. Significant difference in appearance caused by the fact that the starting and finishing points of the stripes not fixed.
Well, what we're dealing with in 194 and 195 is the question of clarity and precision. The visual
and you seem to be proceeding on the assumption that the reasoning in 194 and 195 is solely based upon 193, when 193 starts with the word furthermore, and she's already identified what she considers to be a significant problem in 192.
And I'll come back to that in a minute, if I may, because that is our last ground 4, and why we it's in that context that I was going to address my lords on para 192. But if I might just finish what I wanted to say on ground 1 and Dyson. Another problem we say with the judge's analysis at 194 and 195 is that they are inconsistent with the conclusion that the judge reaches at 135. That's where, as I've shown my lords and my lady already, she had accepted the argument that variation per se isn't objectionable. But as we explain in our skeleton at paragraph 50, any mark that includes a variation will necessarily allow for versions of the sign that aren't depicted in the pictorial representation. So the point being, the judge having accepted that variation per se is permissible, it follows that there will necessarily be marks where the scope of the mark includes versions of the mark that aren't depicted in the pictorial representation. And as a consequence, the fact that there are so-called unrepresented signs, quote unquote, can't be determinative of the question of registrability. They're simply a consequence of the fact that there's variation in the first place.
194. I don't myself read it as suggesting that the judge said the answer to this case lay in the fact that there were what she called unrepresented signs. She's simply making an observation, which we can all agree about, that there are, if the term is useful, unrepresented signs because it's a consequence of something being an example in a drawing. I could understand your argument on this particular point if she was making that into a test which you had failed. But she's only making an observation there, isn't she?
Well, in our submission, it is the reason why she is reaching the conclusion that the mark is not clear.
Right, I understand the argument. Thank you.
I'm very conscious of the time.
Well, as I say, how long were you intending to be?
Well, I wasn't going to say very much at all about ground round
I
3.
I just want to know how long you were intending to be.
I was going to try and finish my lunch.
Yes. Well, I'm sure there won't be any difficulty if you need to mildly overrun, but if we could just have some idea as to how long that might involve, so that everybody knows where they stand.
Indeed. So I think I can address my lords in the next 10, my lady, sorry, in the next 10 minutes on ground 4.
Yes.
But if I might have the opportunity just to speak to my clients over lunch, and if there are any points I need to pick up when I come back.
Of course. Well, I'm sure that there's not going to be argument. If you need 10 minutes after the break, then you shall have them.
Thank you. Thank you. So like I say, I wasn't going to say very much more about ground 3 because I think I've effectively covered that already. That's the ground where we say the judge wrongly confused the requirements of clarity and precision with a requirement that any variations of the mark must be depicted in the pictorial representation. And the argument basically is based on the fact that she holds at 194 that the words 1/3 or more are clear in themselves. And we agree that they are. And since those words are clear in themselves, and they are the only means for providing variation, it follows that the scope of the variation permitted by the mark is also clear. And we say that that's illustrated by the fact that the judge herself was able to identify the variations in the judgment at 191. So it's simply not correct, we respectfully submit, to say that the variety of different forms isn't readily ascertainable from the words and the illustration together, which is what the judge says at 195. But because, and we say because what the judge says at 195, namely that the pictorial representation was only an example, was wholly unclear, for the reasons I've already said, that's either based on the error in 193, or it's based on a point of principle which is wrong, the unrepresented signs point. So that's what I was going to say about ground 3. So moving on to ground 4. This is the ground where we say that the judge got her assessment of the degree of variation encompassed by the marks wrong, because she wrongly focused on visual differences and omitted to consider properly the impact that variation has on the origin message. And we address this from paragraph 67 onwards of our skeleton, and it relates to paragraph 192, which we've touched on already. And we say the vice in that paragraph was that the judge made an assertion at the end that the differences in appearance are significant, but she didn't analyse the relevance or otherwise of those visual differences in a meaningful way. She seems to have proceeded on the basis that visual differences alone is enough, without asking herself the question as to whether those differences have a relevant impact on registrability. And as I think I've already submitted to my lords and my lady, our case is that there can only be 2 ways in which visual variability might be relevant. One is if it impacts on the clarity or precision of the mark to such an extent that it is not possible for the reader to ascertain the subject matter of the mark and its scope of protection. And the other is if it undermines the origin message such that the mark cannot allow the reader to perceive and recall the mark and use that recollection to make a repeat purchase. And I've already explained to the court why we say the variations permitted within the scope of the mark don't impact on clarity and precision. And as a consequence, we say there's an error at 192 where the judge relies on what she describes as these significant visual differences without more. What she should have done is to assess the visual differences by reference to whether the consumer can recall the same mark and rely on that recollection to repeat the purchase, which we say she was required to do. And if she had done so, she would have realised that the visual variations weren't significant in a relevant way.
Is that the only test? You're focusing only on the consumer there rather than the registration? Because in your 2 points, the clarity of the first one is about the registration process and competitors looking at the register, isn't it? Does that add anything to this?
No, well, like I say, there are
in terms of what you say the judge should have done.
Well, she goes on to consider the question of clarity and precision in 194 and 195.
So you say what the thing that she's failed to do is the position that the consumer will repeat.
Yes, yes. And perhaps I can explain our position by reference to the Dutch decision, which is in Authorities Bundle A2. And it's tab 16. And the translation starts on page page 297. And the relevant part of the decision relates to what's called position mark 4, which you see on page 304. And then the analysis is at page 317. And I think it would be quicker if I could ask the court, please, to read paragraphs 4.3 through to 4.5.
Yes. Yes.
So the arguments are summarised in paragraph 4.3, and the court can see that they're same as the arguments pursued in this case. Then at paragraph 4.4, the court holds first that there's no inconsistency between the pictorial representation and the description. Secondly, that just because the mark protects variants that are not depicted, it does not mean that the mark is invalid. Third, that the object and extent of the registration can be precisely determined from the mark as a whole. And in that context, it observes that the dominant components of the mark are not affected by variations in length. So they're always 3 parallel stripes, they're always of equal thickness and length, with equal spacing, the same colour, set against a contrasting background, in the same position relative to the outer seam of the trouser in that case. None of that is undermined by the fact that the stripes can vary in length with a different start and finish. And that's because the length of the stripes don't contribute in a relevant sense to the recognition of the mark. The degree of variation within the scope of the mark is consistent with the nature of the mark, if you think about it, because it's a position mark on a garment, and the pictorial representation will only ever be an example precisely because the garment itself isn't part of the mark. And so the look of the garment can change, including the length and the style of the sleeve. And so necessarily for one and the same mark, I'm sorry, I'm using sleeve because we've been talking about the top. This one is a trouser, but the point is the same. The consumer isn't going to rely on the length as specifically as part of the origin message, because they understand that sleeves can be of different lengths, trousers can be of different lengths. And moreover, in contrast to something like a word mark or a device mark, the nature of this kind of mark means that the degree of permissible variation is likely to be higher because of the fact that the pictorial form it will only ever be limited to the nature of the sign and where it's positioned, and can't cover the underlying product.
Is that a good moment
Yes.
for us to pause?
Thank you. I haven't quite finished, but I definitely will be no more than 10
Yes.
minutes.
Well, you can sweep up anything at 2 o'clock.
All eyes in favour.